Hello and welcome to today's webinar on pensions and divorce. My name's Lisa Webster and I'm one of the senior technical consultants here at AJ Bell. Before we start into the webinar proper, I just wanted to talk a little bit about the guide to treatment of pensions and divorce from the Pensions Advisory Group. Sure, a lot of you who are involved with pensions and divorce work are probably familiar with this already, but for those that are new to the area, or if you only have occasional cases, you might not be, and it's worth drawing attention because it's a really good source of information. So what the Pensions Advisory Group did is they set up an interdisciplinary discussion group, which had lawyers, actuaries, financial advisors. The idea was to try and achieve better understanding and consistency of how pensions are treated on divorce. So this was to improve practice and get better outcomes for divorcing couples. The report is quite in-depth. It's 176 pages long, but if you're looking for information on specific issues that you've not come across before, if you've got complicated arrangements, you have points to consider, for sort of defined benefit schemes, complications on that, things like valuing assets, how you value them for offsetting, etc. Then there's lots and lots of information, and it's a really good reference document. And you can find that on the newfieldfoundation.org website address that is there. Another bit of information I just wanted to mention before we sort of get into the details are the changes that are coming in terms of how you can actually get divorced. Sure, a lot of you will be aware of the Divorce, Dissolution and Separation Act that got royal assent last year, 25th of June 2021. And this was commonly referred to by the media as the No Fault Divorce Act or bill when it was going through Parliament. So this actually became an act last year, as I said, and it was due to come into force from autumn this year, but it has been delayed a little bit further. But we have now had it confirmed in Parliament that it comes into force from 6th of April next year, 6th of April 2022. And the idea of this act is to make it easier to divorce. So there will no longer be a need to apportion blame. So it's possible to file for divorce with a statement of irretrievable breakdown without having to say one party or the other had intolerable behaviour or having to wait for your 2-year separation. So the idea of this act is to reduce conflict, especially when there's children involved, and to make the whole process less acrimonious. Because if you don't have to say that somebody's at fault. So you can see the positives in it, but there have been some concerns in the industry that if it's easier to get divorced, that financial affairs and pensions in particular may not be looked at properly. The view is there's more scope for getting it wrong. People think it's easier to do things by themselves, which in a lot of ways it will be, but they maybe don't look at the financial affairs probably for doing it by themselves and not taking, looking at it, taking appropriate advice. But obviously it becomes even more important because, as we all know, pensions are far from straightforward. Okay, so in terms of what I've got on the agenda for today, first of all, we're going to look at sort of valuing assets, not just the pension, but wider as well. We'll look at what we consider with that. Then I'll look at more detail of the process, pensions and divorce, and what the options are with pensions. Some important sort of terms that we have when we're looking at pension sharing. So the effective date, the importance of that. We'll also look at the implementation process and practical issues to consider when you're dealing with pensions, look at the difference between qualifying and disqualifying pension credits, what that means, and then finally I'm going to look at the protection implications for members that are involved in pension sharing who already hold protection, lifetime allowance protections, what that means for them. So to start off with then, looking at sort of valuing assets. So you have a couple who are getting divorced. In terms of the financial split of the assets, what you're going to do, you need to look at all the assets, both pension and non-pension assets. So, obviously you look at the house, ISAs, other investments, whatever else they have. In terms of the pension side of things to consider really. So sometimes it gets forgotten about state pensions now. State pensions aren't shareable pension rights, but that doesn't mean to say that they shouldn't be taken into account when you're looking at the big picture and looking at what people can live on, what they're going to have. Obviously, it'll depend a bit on the age of the client, how immediately relevant it is. but it's certainly something that should be in the picture. Death benefits, obviously it's not going to affect their how they maintain their living standard now, but particularly in cases where you have wealthier clients, whether they have death benefits involved or the form of those death benefits in their pension, what they can leave after them. For those that probably aren't going to use all the pension, wealthier clients, that will be an important factor to them. So guarantees, when it comes to looking at pensions and valuing them in terms of how they are split, there are huge differences in terms of the different types of pension and what they're actually worth, and it's not just the monetary value, so it's not just the cash equivalent value. So with the DB scheme, you're going to have guarantees on that, which you're not going to have under DC. Also with the DB, the transfer value is going to be calculated by the trustees in accordance with their own rules, so it's going to be different from one scheme to the next scheme. It's very different. Somebody might have, let's say, £200,000 in a DB scheme as the cash equivalent transfer value. You might get given that by the trustees, but you've got a £200,000 DC scheme. Doesn't mean that they're actually worth the same in the hands of the client. Obviously, it can cost a lot more to buy on the open market the same guarantees even that you can get under the defined benefit scheme. So it might cost you a lot more than 200,000 in defined contribution world to buy that the same as you could get under the DB scheme. So there's all these things to take into account, which means when you are valuing the assets and assessing the split between them, it's not just the monetary value. Obviously, timing is going to make a big difference. The age of the clients, whether they can access the benefits today or not, how far away they are, and obviously you might have age gaps between the couples, which means it might be quite difference between the parties, and then taxation issues as well. Obviously, when you're talking about taking pension income, it's taxable income, so when you're looking at that compared to other assets, money that they have in ISAs or other investments that they have elsewhere, which wouldn't be taxed in the same way, they're going to have different values in the hands of somebody who's a high rate taxpayer than somebody who's a basic rate taxpayer. So all of these can make it quite a complicated decision in terms of what is fair split of the assets and immediate needs versus long-term needs. There is a lot more, say, in depth around this area, as I say in that report that I referred to right at the start, that if you have more queries about that, I would use that as a good reference starting point when you're making these kind of decisions, having these discussions with clients. So moving on to the actual sort of process itself then. In terms of sort of legal documents, things that we have with the divorce process, the decree absolute is the final legal bit that ends a marriage or civil partnership that's granted by the court. We also then have court order alongside that, and in terms of how the financial assets are split. So we will have a consent order, which is basically when the parties can agree how the assets are going to split between themselves, obviously with advisors as appropriate, and then the court is basically like rubber stamping that. Where it's contested, then the court would have to decide the split. So obviously there would still be all the evidence would have to be gathered of what assets are involved, what the parties have, given that to the court, and then it may be that the court makes the final decision on how they're split, in which case you would get a final a financial order on that. Scotland, it can be slightly different. You can have a court order, it's the same as you can have in the rest of the UK, but you can have a qualifying agreement, which just has to be registered in order to be enforceable, and that can be applied to pensions as well. If you have people that are divorced overseas, so they go through courts elsewhere, that cannot be applied to a UK pension scheme. They would still have to go through the UK court in relation to any UK pensions that they held. So in terms of the options then, what can you do with the pension? How can they be split? If you've decided how you want to split it, what are you going to get put in that consent order, that financial order, in terms of how the assets are split? In the olden days, before 1996, offsetting was the only option. Basically, you couldn't split pensions. So you'd have to look at whatever assets there were. If somebody had a big pension fund and there was other assets, you'd offset them against each other. Not always possible, particularly if there's a sizable pension fund, is not always even desirable, because if it's a future, especially if that's something you can't access, depending on the age of the client, if for 20, 30 years, it's not going to help with their immediate living costs. Offset as well, for those reasons, really, it's not always done on a pound for pound basis. It doesn't mean because you've got a £100,000 pension fund, you offset it against £100,000 of other assets. I say it's not as straightforward as that. So timing and taxation issues are the main ones. Since 1996, we have been able to have earmarking or attachment orders that came in as part of Pensions Act 95, it's in force from 1996, which was definitely sort of an improvement where offsetting wasn't an option, or offsetting was very difficult, or the numbers just didn't work out. And they were reasonably successful, I suppose, to a certain degree, if you're talking about scheme pensions, if you're talking about final salary, where the member themselves doesn't really have control of the investments, doesn't have control, or has certainly less control over how the benefits can be taken. Because with an attachment order, it basically means that when the pension is paid out to the pension member, a certain percentage of it, as agreed in the courts, is paid to the ex-spouse. But the ex-spouse is the recipient of this attachment order, has absolutely no control over anything, has no control over investments, has no control over the timing of those payments, the form of the payments. It would stop if they were to marry or divorce, if they were to remarry or die. In most cases, it stops if the original member dies. So the ex-spouse might live for years after them, but they wouldn't, obviously once it's gone, it's gone from them as well. So it's really not ideal. And when the light of pension freedom's coming along, it's made the situation a lot worse in terms of attachment orders. Obviously now there is no requirement to take income at any time. So particularly, if there's been a nasty divorce, people are not getting on well at all, and the pension member may have, the original pension member might have a pension, they may also have other pensions they've saved, obviously since divorce elsewhere, other sources of income. They may never take their pension, and if they don't take their pension, then the ex-spouse never gets to get any of it. So they don't have any control over the investments either. Another point is that it's always taxed on the original member. So if the original member is taking income and they're a high rate taxpayer, and the ex-spouse is only a basic rate taxpayer, they're still effectively paying high rate tax on it. Also, with pension freedoms, we have this issue of taxation of flexible payments, where somebody takes a one-off lump sum, maybe take an annual payment or they take an ad hoc payment, and they are taxed as though they're going to take 12 of those throughout the year. When this leads to a problem with overtaxation, which has been well documented, I think, in the press, and covered it in some of the earlier webinars that I did to talk about benefits and how that works and the issues with that. You can reclaim the overpaid tax, but only the member can reclaim it. So even if the tax has been deducted at a higher rate than it should have been in the hands of the ex-spouse, it is the member who gets that tax back, the original member. So really, really lots of problems with earmarking and attachment orders, to the extent that if you have them in place now, because they were put in place a long time ago, depending on the individual circumstances, obviously, but it may be appropriate to go back to court and replace the attachment order with a pension sharing order, because there's a lot of advantages of a pension sharing order over an attachment order. The only reason I can think why people would want to do an attachment order now, the only possible one, is if the original pension scheme member is protected retirement age, because it does allow obviously to access their benefits earlier at a time, and the ex-spouse could benefit from that as well, obviously if it's also harmonious and they're in agreement about that. But there's potentially also if you have a big age gap and the original member is a lot older, obviously they can start taking their income, and actually it allows the ex-spouse who's much younger to access pensions before age 55, because effectively it'll always be based on the member's age, the ability to take income. But so normally there's just a lot of issues with them, and I wouldn't recommend them, say very limited circumstances where that would be the best option now. So what we do have now, of course, is pension sharing orders, and so that's what I'm going to spend the rest of the time talking about. So these came into place as part of Welfare Reform and Pensions Act in '99, actually came in December 2006. They can also be applied to civil partnerships from 2007 onwards, that is the case. And the real advantage of pension sharing orders is they do allow a clean break between the parties. So there is a pension debit on the pension scheme member, and a corresponding pension credit for the ex-spouse, and they can then transfer that into a pension in their own name, of their own choice, and have complete control over it. So it does allow a complete clean break. It can be applied to most types of pensions, so you can have it on occupational, personal, DB, DC, whether it's in payment or not, deferred members, retirement annuity contracts, Section 32s, whatever it is. I say you can't apply anything to state pension, but that's aside, it's pretty much most kinds of pensions you can apply a pension sharing order to. The exception to that is beneficiaries' pension. Now, this never used to be an issue, or certainly much less of an issue, because before pension freedoms came along, so you could only have a dependents pension, which would be for somebody, child under the age of 23, or for widow, normally. And so you didn't have many beneficiaries' pensions that were likely to be involved in a divorce, because somebody would actually have to be widowed, remarried, and then divorced. So it was possible, but probably not going to happen very often. But of course, under pension freedoms now, anybody can be a beneficiary. So we'll be seeing an awful lot more of like adult children inheriting their parents' pensions as a beneficiary, and obviously at an age where they're probably prime divorce candidates. So there could be quite large beneficiaries' pensions that the member holds, but they are beneficiaries' pension, that's not their own pension. So it's just worth bearing in mind when you're deciding the split of assets that you can't put pension sharing order on those beneficiaries' pensions, only on rights built up in the member's own name on that. Pension sharing orders work in terms of they state a percentage of that pension fund, the rights under that pension fund, that have to be transferred to the ex-spouse. Scotland is the exception, because you can put a monetary amount on the pension sharing order, but you cannot do that anywhere else in the rest of the UK. That is just in Scotland. You can't specify which assets are going to be split. You can't say, I'm going to keep, if there's property in the pension fund and there's some other funds over here, I'm going to pay those to the ex-spouse. It is just a percentage, that's all that can be stated on it, say with the exception of the pounds figure in Scotland. It's still no assets on that. In terms of transfers, then so the ex-spouse can then say transfer it to pension wherever they want, in most circumstances in their own name. Under DB schemes, most private sector DB schemes, they depends on the scheme rules, they can allow the ex-spouse to become a member of their scheme and keep the rights in their scheme. But with most private sector DB schemes, they're not going to want to do that, in all honesty. You might find the odd one, but it'd be quite unusual. So more likely you're going to have to pay it out. So they won't offer an internal transfer. Public sector obviously is a little bit different. So the unfunded public sector schemes, NHS, teachers, armed forces, civil service, they will. So then the ex-spouse effectively will become a member, different category of member of the pension scheme, with it is still in their own right, their own benefits, separate to their ex-spouse, the original member. but they will have an internal transfer effectively become members of those schemes. Moving on now, there's a couple of sort of important dates in the process of how we actually implement pension sharing orders and the practicalities of it. First date we have is the effective date, which is a very important date in terms of what it means in the process for pension sharing orders. And this is the date that the court order comes into effect. In legislation, this is called the transfer date, which I do find slightly confusing because nothing actually gets transferred. It's not the date that the transfer happens from the original member scheme of the pension sharing order to the ex-spouse. It's not, it's the effective date. That's how I like to call it, because that's what it feels like to me rather than a transfer day. But if you read it, obviously legislation or guidance or other places, it is the same thing. It's called the transfer day officially. Basically what it means is on that date, on the effective date, any contributions that come into the scheme or transfers in after this date aren't shareable rights. So if you have a pension scheme member as your client and he's or she they've got a sizable pension fund, they know this pension sharing order obviously is coming into place, they're wanting to make contributions for their normal tax planning, employer contributions for the year end or whatever it is, they want to make contributions, and obviously they're concerned that actually they don't want to put it in, and that means more of it goes to their ex-spouse. If it's after the effective date, it doesn't matter. They don't need to necessarily set up a separate pension and then go and put it somewhere else so it's completely separate to the scheme that's got the pension sharing order on it. If they put it in after the effective date, it's not shareable, so their ex-spouse won't be getting a share of those rights, those new rights that have come into the scheme. Conversely, any income taken after the effective date doesn't reduce the shareable value. So if somebody is taking income payments after that date, when we do the calculations of the amount that gets paid out on the pension debit, it won't be taken, it'll account for the fact that income is taken after that date, and it won't reduce the share for the ex-spouse. It is another reason why it's very important is if the member dies. If the member dies after the effective date, even though the physical transfer, the pension sharing order, hasn't been implemented, it hasn't gone through, we would still go through the process of that pension sharing order as if the member was still alive. So it would still be paid across to the ex-spouse. They would still get their pension sharing order, and then once that has been paid out, then the remaining funds in the original member's pension scheme would be dealt with as normal under the death benefit process. But after the effective date, the bit that's going out, that won't be part of that anymore. And the effective date will always be the later of the decree absolute from the court, or 20 days after the pension sharing order is granted. Sometimes it might be 21 days, it's normally 28 now, it used to be 21 days sometimes, but it does state that on the pension sharing order, the annex to that at the back, it'll always state it on there, and they say normally it will be 28 days after it's granted, I say, or the decree absolute. So once we get that, that will be the effective date. So once you've got that, in terms of how you actually implement the pension sharing order, you need to send the pension sharing order and the annex along with a decree absolute to the pension scheme that is being applied to the pension scheme administrator, and they need to send the completed pension sharing discharge form or all the paperwork. So obviously the first bits of the two parts, the two bullets on that, are the legal documents that we need to say, yes, this is a pension sharing order, this is all finalised, this is what we have to do. But the last bit is like, well, where are we sending it to? And we do find that we quite often get delays on this. Maybe the original pension scheme member is, very cooperative. They do everything properly, they send us all the information, but it's the ex-spouse obviously needs to tell us where they want us to send it to. And it's not unusual for them not to have decided what they're going to do with this pension sharing order when they've got it. And that can really hold things up because we can't do anything with it. And it also, it kind of leaves that, it's not great, because it kind of leaves the pension scheme in limbo for a little bit, because the pension member still isn't controlling the investment decisions, which isn't great for the ex-spouse, because it might not be suitable for their risk profile and what they want to do with it. But it's not great for the member either, because it may have certain restrictions imposed on them in terms of if they want to take income, or even if they want to transfer out, obviously, because until it's dealt with, the pension scheme administrator is obviously conscious that there is this pension sharing order that they are going to have to fulfil, and they need to make sure there's sufficient funds in there to do that. So, it can have restrictions sort of from disadvantages from both sides. So really, it's important to get that as quickly as possible, and way before everything is finalised. If you're advising from the ex-spouse's point of view, to make sure that they know what they're going to do with it once they receive the pension credit, where it's going to go. So once we have all that information, then this implementation period starts. So once those 3 bits of information, pension sharing order, the decree absolute, and the information, the paperwork that's necessary for us to actually make the transfer, once the administrator has all of that, then regulations state that scheme administrators have got 4 months to implement the pension sharing order. Within that 4-month window, there will be a valuation date. And the scheme administrator can choose wherever in the window they want to make that valuation date. Now, we will always do it from day 1. So it's the day that we receive all the paperwork, the final bit of paperwork that we need to be able to implement this pension sharing order. That's the date that we will use as valuation. But I say the scheme administrators may do it differently. They're perfectly entitled to do that, as long as it's within this 4-month window. It's not the same as the effective date, because the effective date will be, say, either the date of the decree absolute or 28 days after the pension sharing order. If somebody takes months and months to send us the paperwork for the transfer, this could be quite a long time after the effective date. There can be quite a difference in them. So this is the date where we actually value the assets, but obviously we've got to go back to the effective date to take into account any contributions, transfers in, transfers out, income payments. So we will take that into account when we're working out the value of the pension sharing order in terms of pounds and pence. Say it can be different in Scotland because you might have a pounds and pence figure to start with, but for the rest of the UK, it's actually only when you have the valuation date that you will know exactly the pounds and pence that the ex-spouse is going to get. Until that, it's just a percentage, which obviously is going to fluctuate in terms of monetary terms. So we have this 4-month window as per regulations. However, Ombudsman rulings show it expects pension sharing orders to be implemented as soon as possible. So we have got cases where people have made complaints that have been upheld with the Ombudsman, even though it was completed within 4 months, because there was still classed as being unnecessary delays. But on the flip side of that, we have got cases where it's taken longer than 4 months, but if the scheme administrator isn't at fault, because if they're relying on the parties for information and it's not been forthcoming, there's been other issues, then they're not being held responsible. So 4 months is what it should take, but actually it should just be as soon as possible. As I mentioned just now, you don't know the monetary figure, say with the exception of Scotland in some cases, until you've got this valuation date. And that can cause some issues because it can mean that people don't get what they're expecting. I don't really know what the solution to this one is, other than trying to keep your time frames as short as possible to minimise the risk. But obviously, as we know, we can still have huge market fluctuations in a very short period of time, so not necessarily a complete solution. So as an example here, we've got Tony and Melanie who are getting divorced. 1st of February 17, Tony's SIPP is valued at £350,000, and that valuation is then decided to be used, but it doesn't actually go through. The pension sharing order doesn't go through until December, 8th of December, so that's going to be 50% based on that initial valuation of 350,000. So effectively, the ex-spouse, Melanie here is thinking she's going to get about 175,000. We then have the decree absolute granted on the 20th of December. So the effective date is the 5th of January because it's the later of the decree absolute or 28 days after the pension sharing order. So in this case, it's been the 28 days. They then send all the documents to the provider, fairly sharpish there, on the 10th of January. So we have the start of the implementation period. The SIP administrator decides to use a valuation date of the 20th of February. The SIP is now valued at £290,000. They then make the transfer out, so Melanie ends up with 145,000. So obviously that's a lot lower than 175,000 you were basing it on initially. I think here really is you want to get that valuation at the top as close to the date of the pension sharing order as possible. And really it's just to make sure, you know, when you're advising clients, you know, that it can fluctuate and it's not a guaranteed, it's not set in stone. These figures are going to hopefully things move the other way, not downwards as in this case, but you know, it's something that they just need to be aware of. It's not a guaranteed figure when this is all going through. In terms of some other practicalities to consider whilst dealing with them, the first one on here, property and liquid investment, is probably the most obvious one, but it amazes me we do still see from time to time pension sharing orders coming in, you know, 50% going to the ex-spouse, but 90% of the pension fund is in property. And these are often the cases that we see, like when people complain about delays, actually when it's found not to be the scheme administrator's fault, it's, you know, because there's a liquid investments in there and, you know, things take time to deal with. I mean, ideally in that scenario, if you've got a property taking up most of the pension fund, you're using offsetting where you can, as you would if the property wasn't in the pension scheme, if it was just held privately. There are cases when you can do a forced sale of property, but it's very difficult to do, especially when the member is trustee, which is often the case when a property is involved in the pension. There can be cases where the member can buy out the ex-spouse, possibly using other funds or another director of the company if it's a business premises that, you know, they could come in, things like that. But all that needs to be thought about really before the pension sharing order lands on the scheme administrator's desk, because there are, you know, lots of problems with that. It is good practice as well, particularly if you do have complications or anything other than the most straightforward case, is to send a draft pension sharing order to the scheme administrator in advance before everything's finalised, and just say, you know, can you see any issues with this pension sharing order as it's drafted? You know, so if there are problems, if they think there's going to be anything that's going to cause delays, you know, if you can iron it out now or look at alternatives, that can save a lot of headaches further down the line. So yeah, so we'll see on that one. A couple of other things on here. Capped is just, you know, if you've got a member in capped drawdown, obviously they would need to have a review of capped drawdown. That needs to happen from the effective date, though it's not implemented until the next pension year on that. But they do need to have that revalued. So obviously they would see that once it comes in the next pension year, they're going to see a drop in the maximum income they can take, unless they choose to switch to flexi. Yeah, want to be aware of. Fees is an interesting one. Pension scheme administrators need to tell you their fees up front right at the start of this process, because it needs to be included on the pension sharing order on the annex as to how the fees for dealing with it are split between the parties. And if fees aren't agreed up front, then there can be issues with actually the scheme administrators being allowed to take them out of the pension fund. So that needs to be all clear and upfront. Information, obviously, is quite a sensitive subject with divorce, and you can see there's good cause for the ex-spouse to want to know how much is in there, or soon to be ex's pension fund. But obviously, we have data protection. You know, we can't just give out information. So we are only required to give information on the pension fund to the pension scheme member. Obviously, if they have an authorised advisor, we have a letter of authority, we can give it to them, and to the courts. So the ex-spouse doesn't have a right to know what's in that pension fund. So obviously, if it's all amicable, if the pension scheme member, the client wants to send us a letter of authority, and if they want to give that information to their ex-spouse, they can do it. If they send us a letter of authority telling us we can give it to the ex-spouse, if it's all amicable, they may do that. It can make things a bit easier, but otherwise, it is only the client, the member, and the courts that we provide that to. Okay, moving on then. So we have qualifying or disqualifying pension credits. So this will depend whether the original pension scheme member was in drawdown, if they've accessed their benefits before the pension sharing order comes into place. So if they've already taken their tax-free cash, basically, it means that the credit will be a disqualifying credit, so that the ex-spouse receiving the pension credit cannot take any tax-free elements. They can't have pension commencement lump sum or an uncrystallised funds pension lump sum. They can't have it because that's already gone. The positive side of this is if they take any income from a disqualifying credit, it doesn't count. It doesn't trigger the money purchase annual allowance, so it doesn't restrict their ability to make contributions themselves. So when you're looking at splitting the asset and what's the best way of doing it, it's certainly worth considering. On one hand, a disqualifying pension credit will have less value than a qualifying credit, because obviously it's all going to be taken as taxable income. There's no tax-free element. But particularly if somebody's like at the younger end, still able to take benefits, over 55, but they might still be working for another like 10 or 15 years or whatever it is. The fact that they can take some income from it, but also doesn't restrict their ability in the future, that could be valuable in a different way as well. So worth taking into consideration. Conversely, if it's from uncrystallised rights, the pension credit, then it's a qualifying credit, and you can still take benefits in the normal way. PCLS is available, you have PLS, but taking income from those will trigger the NPAA as usual. Okay, finally, this last section, I'm going to talk about the protection issues around divorce. First of all, looking at primary protection. So if the pension scheme member who has the pension sharing order applied to their pension has primary protection, primary protection can't be given up in the same way that enhanced can, but it can be reduced or even lost. If somebody has a pension debit on their pension, they have to inform HMRC. Regulations just state without undue delay. Doesn't have a date on it, doesn't have a timeline on it, but yeah, as soon as possible. And the reduction to their protection is going to apply from the effective date of that pension sharing order. So I've got a couple of examples of how it works in practice. So John here has got protected pension rights of £3 million at A-Day. He then gets divorced and he has a pension debit of £300,000 this year. Now, when you calculate this, there's no revaluation or adjustment of the amount of the pension debit for time. Doesn't matter how long ago, how much time has passed since A-Day. Basically, all you do is deduct that pension debit from the amount of their rights, their A-Day rights, and then you recalculate it as if you were applying for primary protection now. So his protected pension rights now would be based on 2.7 million, as if he had 2.7 million pounds at A-Day. So it's an enhancement factor that you get under primary protection. Originally, when it was calculated at A-Day, it would have been the 3 million less £1.5 million, which was the original lifetime allowance, divided by the lifetime allowance, 1.5 million, is 1. So we'd have had an enhancement factor of 1. Whereas now you recalculate that based on 2.7 million. You take your 1.5 million, so it's your excess over the lifetime allowance as it was introduced. Divide that by 1.5 million. So its enhancement factor is now 0.8. When you calculate personal lifetime allowance for somebody with primary protection, they have this underpinned lifetime allowance that you use of 1.8 million. So you have the 1.8 million plus whatever your enhancement factor is times 1.8 million. So in this case, it means his protection now will be 3.24 million after he's had his reduction. So he would have to write to HMRC with an undue delay, write to HMRC, and what they would do is they would give up his primary protection certificate. They would issue a new certificate with the new enhancement factor of it, 0.8, and that's what he would use going forward. If he's already taken benefits, they don't need to be recalculated. It would still be based on what it was at the time, because he had primary protection when he took benefits. Another example of primary protection then, this is Jeff. He had protected rights, same 3 million at A day as before, but he's had a pension debit of 1.6 million happening in this year. So his pension rights are now based on 1.4 million at A day, which means he doesn't qualify for protection, because you had to be over the newly introduced, as it was then, lifetime allowance of 1.5 million to qualify for primary protection. So he doesn't qualify at all. So in this case, he would tell HMRC, they would just take his certificate off him, and that would be it. He doesn't have any protection anymore. So for Jeff, before the debit, he had a protected lifetime allowance factor of 1. His enhancement factor was 1, because he had double the standard lifetime allowance at A day. So with the underpin, that would mean his lifetime allowance before his pension sharing order, his personal lifetime allowance would have been £3.6 million. After the pension sharing order, he's just got the standard lifetime allowance. He has no protection anymore. So his lifetime allowance for this year, 1,073,100. So it really shows how valued the underpin is for somebody with primary protection, because it means he's lost over £2.5 million of protection for a £1.6 million debit. So if you are dealing with very wealthy clients who have large pension funds and have protection in place, who are getting divorced, wherever possible, it's worth trying to keep the A-day value, somebody with primary protection, above 1.5 million, even if it's just a fraction above it, because it means they will have the underpin of the 1.8 million, which is so valuable, and it just makes such a huge difference losing that underpin or not. So it's not going to be appropriate in all cases, but if you do have anybody in that scenario, it's definitely worth bearing that one in mind. For those with enhanced or fixed protection, having a pension sharing order, pension debit, it doesn't have a direct impact. You don't lose it, but obviously you're going to have a much lower pension fund value now, and you have limited scope for rebuilding it. So there's very limited scope under DB entitlement, and it's lost if you make any contributions under a defined contribution scheme. So you basically, yes, you've still got your protection, but it'll depend how much the debit is, how far down it brings you, whether it's worth losing the protection so you can build up more pensions or not. So it will depend on the level of what you're left with in your pension. Finally, individual protection for the member. So similar to primary, in that it can be reduced or lost. And you have to inform HMRC if you have a pension debit. With this one, the regulations say you have to do it within 60 days. The member has to do it within 60 days. If they don't, the member might be liable for penalties. And again, once the new protection level is calculated, if it's reduced, they will issue a new certificate. If it's IP16, they don't issue certificates, it's just reference numbers, because it's all online. If it's lost completely, obviously you just lose it, that's it. Works slightly differently because there is a revaluation element to it. So if your transfer day, which is the effective date, changing terms here, sorry, it's the same thing, is more than 12 months after the date that you've got protection, so it'll either be 6th of April 14 if we're talking about IP14 or 6th of April 16, but the pension debit is reduced by 5% for each full tax year. So examples for that one to explain that one a bit better. So first one here, we have Joan, who had funds valued at 1.6 million on the 5th of April 2014 and therefore holds individual protection 14, which would be, because the maximum on that was 1.5 million, so she'd hold it at 1.5 million. Then has a pension debit of £300,000. with the effective date of that, or transfer day, same thing, of 15th of June 2016. So that's more than 2 full years since she had the protection. So it's a 5% reduction for each year. So that's a 10% reduction. So effectively that you deduct 90% of 300,000, so £270,000 from the 5th of April fund value, which is 1.6 million. So that reduces her protection down to 1.33 million. So she would get a new certificate with that on, the new individual protection at 1.33 million. Second example, we have Jill, who had also had funds valued at 1.6 million on 5th of April 2014 and holds IP14 at 1.5 million. This time the pension debit is £400,000 and the effective date is 15th of June 2015. So this is just 1 year, 1 full year after the protection applies from. And so there is a reduction of 5% on that figure. So now she has a reduction of £380,000, which reduces the 5th of April 14 value down to 1.22 million, sorry. The minimum value for IP14 was 1.25. So individual protection 14 was when the annual allowance was reduced for, lifetime allowance was reduced from 1.5 million down to 1.25 million. So you had to have funds above 1.25 million to qualify for individual protection 14. She doesn't qualify, so the protection's gone. Finally, I'm just going to have a look at the implications for the, called the ex-spouse here. So this is the person who's receiving the pension credit on the other side. So they can have an enhancement factor in certain circumstances, an enhancement to their lifetime allowance. So they can have an enhancement factor when the pension credit was acquired after A Day, that pension was already in payment, and that pension came into payment post A Day. So what it means is that the original pension scheme member has started taking benefits after A Day, therefore that part of the pension has already been tested against the lifetime allowance. So when it gets over to the ex-spouse, when they get it, the enhancement factor is basically to offset the fact that HMRC have already had this tested against the lifetime allowance, so it doesn't get tested. Same funds don't get tested twice effectively, is what it means. This will always be a disqualifying pension credit by the fact we're only talking about pensions in payment. So in terms of calculating the credit factor then, so it is the relevant amount over the lifetime allowance at the time of the effective date. So it is possible on a pension sharing order for it to be made up of crystallised and uncrystallised elements. So it's not always the same as the total amount of the pension credit. It is just the bit that qualifies, which mean that it is relating to benefits in payment that came into payment post A Day. So it's relevant amount over the lifetime allowance. So for example, somebody receiving the pension credit in this tax year that qualifies £400,000, you divide that by this year's lifetime allowance and you get the figure there, which is 0.3727. It is always rounded up to 2 decimal places. So you just ignore anything after the second decimal place. So it is rounded up, sorry. It's always rounded up, sorry. So even if it's like 3.71, it goes up to 0.38, it's always up, not down. So it's rounded up to 0.38. If your recipient of the pension credit has protection themselves, if they have fixed protection or individual protection, when you calculate the pension credit factor, you substitute their appropriate lifetime allowance opposed to the standard lifetime allowance. So for example, if somebody had fixed protection 14 and they had a pension credit 400,000 in this tax year, instead of doing 400,000 over the standard lifetime allowance, you do 400,000 over 1.5 million to give you an enhancement factor of 0.27 on that. In terms of notification then, for somebody receiving the pension credit that qualifies for a pension credit factor, they have 5 years after the 31st of January following the tax year where the pension sharing order took effect. If I show this on a timeline, it'll be easier to follow. So if you have a pension sharing order that is effective in the 2015-16 tax year, the 31st of January following the tax year end is 31st of January 2017. So they have 5 years after that to apply, which is the 31st of January 2022. If you had a pension sharing order in the last year, 2021 year, then 31st of January following that is January 2022. And then you have until 31st of January 2027 to apply. The form you need is the APS 201, APSS I should say 201. So you send that off to HMRC and they will issue with a certificate with details of the enhancement factor, which is then used when it comes to taking benefits. If you have an ex-spouse, so somebody receiving a pension credit who has protection of their own, if they have enhanced or fixed protection and if that pension credit is transferred into a new arrangement, then they lose their protection. But if you transfer it to an existing arrangement, then you don't. So again, when making decisions, you know, obviously if somebody's got enhanced or fixed protection, they're going to clearly have substantial pension savings in their own right. You want to hope that one of those is able to receive the transfer. If it's not, then you do have an issue there. So you definitely want to be aware of. Most cases, you're going to be fine. They'll have an existing arrangement they can pay it into. Primary or individual protection. There is no direct impact on receiving a pension credit on the primary or individual protection level held, but obviously it just means you've now got more pension funds, means you're more likely to exceed whatever your level of primary or individual protection is. Right, just to finish off with then, the value of your pension benefits, so we're looking at valuing assets and how things are split. Value of pension benefits will vary. By that I don't just mean they're going to have different values on them, clearly they will, but it'll be very different whether you're talking about DB or DC, whether you've got guarantees, the age of the client, how far away they are from accessing them, whether you've got qualifying or disqualifying pension credits, whether they've got protection, whether there's going to have impacts of protection on it. There's lots of different factors, which means it's not a straightforward tax position is another one. Positions where it's not just a straightforward, you know, pound for pound value. If you have got illiquid assets, if you've got complicated assets in the pension, then you know maybe considering offsetting where possible might be more appropriate. Just depend a bit on the circumstances. So do take into account any protection. You know, there can be some quite significant implications for people with protection and having pension sharing orders applied to the pensions. Attachment orders can be very problematic, especially in light of pension freedoms. And I think in a lot of cases, it might be worth going back to court to change those and have a pension sharing order put in place instead. So it's not going to be a blanket, that's going to be dependent on the circumstances, but it can be worth considering, certainly. And the final thing is really, don't try and be too clever with pension sharing orders. We try and sometimes see, you know, people trying to move certain assets and move things around, do things, and it is just keep things simple as it was possible. And as I did touch on earlier, you know, if you have got any sort of concerns, queries with it, make sure you send pension sharing order a draft version to the pension scheme first, to the administrator, and you know, you can see if there's going to be any issues and try and iron those out before things are finalised. It can save a lot of headaches later on down the line. But that is all from me for today. So thank you very much for listening. If you do have any questions, then you can pop them on here at the end, or one of my colleagues will be sending round slides, CPD, questionnaire and things, follow up. If you send through any questions, so, you know, they will get to me or one of my colleagues, and we will be happy to help you, or use your usual contacts. They can always get through to us. But thank you very much, and goodbye.